Hi, I'm Emily, and I am here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is, can my Connecticut prenuptial agreement address alimony? And am I still entitled to alimony if I sign a prenuptial agreement?
That's a good question, Emily. There is this common misconception that if a party is signing a prenuptial agreement or a postnuptial agreement for that matter, that they are waiving their right to certain property or waiving their right to alimony. And that doesn't have to be the case. While these contracts certainly can include a waiver of alimony, they don't have to. So alimony, which is also commonly referred to as maintenance or spousal support, is generally the payment of money from one either spouse to the other or former spouse to the other, depending on if it's during the course of a divorce or at the conclusion of a divorce. Now, these payments are often needs-based, and so the thought is that there shouldn't be an obligation to waive alimony simply because you're entering into a prenuptial or postnuptial agreement, because it's needs-based and perhaps one of the party needs the support at the conclusion of the marriage. So certainly the parties can include this waiver, as I said, but they can also include a provision that expressly grants alimony, or alternatively, a third option is that the agreement is silent on the issue. What I'll do is I'll briefly discuss these three different scenarios and how they can play out within the context of a prenuptial or postnuptial agreement. So in the event that the agreement includes a provision that expressly grants alimony, it's important for the parties to address two primary factors within their alimony provision. One is the amount of alimony, and the second is the duration or the term of alimony. So as to the amount, it's important that the parties include language that makes it very clear what their intention is as to what the amount of alimony will be. Now, the amount can be based on a simple figure that the parties actually specifically include in their agreement if they're able to come to an agreement on what an appropriate amount will be, or otherwise they can include a formula, perhaps a percentage of the obligor's income that will be used to determine what the alimony will be in the future. Some parties like to include a sliding scale. So for example, the longer the marriage, the higher the obligation will be. Whatever it is that the parties use, whatever the method is, it's important that the agreement clearly specifies it. So there's no uncertainty, no ambiguity, and no opportunity to have to dispute it in the event of a divorce. I've said it before and I'll say it again. The goal with these agreements, if prepared properly, is to prevent future litigation. It's really to resolve the issues in advance of a potential divorce. And so if the agreement is unclear or vague and has any kind of ambiguous terms, the parties are left to litigate those issues in the event of a divorce. So hopefully by providing clear language, they can preempt that type of dispute. Now, within the calculation, it's also important for the parties to understand that income or finances are subject to change during the course of the marriage. So perhaps what their financial circumstances may have been at the time they executed the agreement are not going to be the same circumstances at the time that they divorce. And so whatever method they choose, it would be really helpful and beneficial for the parties to include some kind of provision that accounts for the fact that their finances may change. They may increase or they may decrease in ways that they can't foresee at the time of execution. So often parties do like to include this percentage strategy because that can help really account for any increase or decrease that they didn't foresee at the time of execution. Whereas if it's a flat fee that they specify a certain number, they may be stuck with that number, but it may not be the most appropriate number at the time of dissolution. It's also really important for the parties to understand that they should account for all different kinds of income or sources of income when they're determining what an appropriate obligation will be. So for example, one of the spouses may have employment with a third party. They may be a W-2 employee, so they will have a base salary, but they may also be entitled to a bonus, RSUs, stock options. There may be deferred compensation that will be paid out. These different types of income should be accounted for when determining what the appropriate obligation is. In addition, there may be other sources of income. So there may be investment income, there may be rental income these different sources also should be disclosed, most certainly, at the time of negotiations and prior to signing the agreement, but they should also be addressed when determining what an appropriate alimony payment is. And this is for both parties. So this applies to the party who will be the recipient of the alimony as well as the party who will be paying the alimony. It's important to have a correct understanding of what their complete financial picture will be so that you can come to a fair and reasonable payment obligation. Now, one thing that the parties may benefit from is including a provision that inserts a floor or a ceiling, meaning a minimum amount or a maximum amount. This is another strategy that the parties may use in order to ensure that the obligation will be something that will remain reasonable in the future. So at least they'll have a range of what the minimum will be, the maximum will be, and something that they both feel comfortable will remain appropriate at a future point in time in the event of a potential divorce. Okay, so now another provision that the parties should include within the alimony portion of the agreement is something that addresses the term or the duration of the alimony. So, for example, the alimony can be paid in one lump sum, and it's essentially a one and done deal, or it can be paid over a 1-year time, 5-year time. It may be a lifetime award, whatever it is that the parties come to an agreement on. They should address that in the agreement. So there's no question, no uncertainty at the time of a dissolution of when that alimony obligation will cease. The parties can even use a sliding scale the same way they can use in the when addressing the amount to be able to say perhaps if they reach a certain milestone, the obligation will continue for a certain period of time. Often parties like to use the length of the marriage as an indicator of how long the obligation will be. So perhaps half the length of the marriage, the obligation will continue. Now, within the provision that addresses the term or the duration, it may be really helpful for the parties to also address any conditions or circumstances that would warrant a termination or an early termination of the obligation. So, for example, if the recipient's income exceeds the income or net worth exceeds the net worth of the obligor, perhaps it's not appropriate for the obligor to continue to pay alimony. Another very common trigger would be if the recipient either cohabitates or remarries and is essentially sharing expenses or receiving support from another party. So the court or the parties may feel that it's no longer necessary for an alimony obligation to continue because the recipient is already receiving some kind of support from another person. So the parties really should, to the extent that they can contemplate all of these different scenarios, it's important to include the agreement that they reach within the terms of the actual contract. By excluding it and just saying, well, I promise if I remarry, I won't collect alimony anymore, isn't really enforceable. It really needs to be included in the terms of the actual agreement. Now, the second scenario rather, the waiver of alimony. As I said earlier, the parties in Connecticut can waive the right to alimony within the agreement. One or both parties can waive it. It doesn't necessarily have to be a mutual waiver. If it is waived, it is important for the parties to know that it is a permanent waiver in Connecticut. So to the extent there is a post-judgment waiver of alimony, meaning the alimony that would be paid after the conclusion of the marriage is waived in a prenuptial agreement or even in the absence of an agreement, but in the context of divorce litigation, that waiver is permanent. Neither party can come back to the court a year later and say, well, I thought I was going to be able to support myself. I'm really struggling now. I need some kind of maintenance or spousal support. The parties are essentially prohibited from ever coming back to the court and asking for some kind of spousal support in the event that they waive alimony. This is really critical. And so therefore that impacts the language that you would want to use in your waiver of alimony. The waiver really needs to be clear and unequivocal that the parties understand this is a permanent waiver and that they're voluntarily and knowingly waiving their right to alimony, and that they understand that if their financial circumstances are to change after the time of dissolution, that they still don't have the right to come back and seek any kind of support from their former spouse. So the one caveat here, however, is that while Connecticut law generally does deem waivers of support as enforceable, to the extent that a waiver would render the waiving party reliant on public assistance, the court will generally deem that waiver as unenforceable or unconscionable or considered a violation of public policy. The courts want to ensure that the parties are not going to be rendered destitute by the agreement. And so therefore, to the extent that one party is going to be relying on public assistance as a result of this waiver, the court will generally deem it as unenforceable. It may invalidate the entire agreement, or alternatively just deem that one provision, the waiver, as unenforceable and try to rework the agreement in a way that wouldn't render the party destitute. So to the extent that your waiver would render one of the parties incapable of supporting themselves or potentially incapable of supporting themselves, really is best practice to try to rework that, either come to some kind of agreement on support or rework the division of the assets and liabilities in a way where the waiving party wouldn't be rendered destitute. So there are different ways to try to work around it, but the best practice really is to ensure that your agreement is enforceable. This is one of the reasons why we really advise people to consult with an attorney during the drafting process, because they may inadvertently render their whole agreement unenforceable simply because they are waiving alimony. And that one paragraph, that one sentence could really disrupt their entire agreement. So certainly if you had any concerns about whether or not a party would be able to continue to support themselves, consult with an attorney and see what other options may be available to you in the event you want to continue to waiver or work around the waiver. The third scenario that I discussed is if the agreement is silent on the issue of alimony. Now, this would mean the agreement doesn't address the issue of alimony at all. Now, this can play out in two ways. The parties, in the event of a divorce, can still come to some kind of an agreement on what the spousal support will be at the time of dissolution. So, for example, they enter into their agreement. The agreement doesn't address the issue one way or another. They're married for a certain period of time. They decide to get divorced, and prior to a final dissolution, they're able to work out what the terms of their alimony will be. They can come to some kind of an agreement and tell the court, yes or no, there will be alimony, and if so, what is the appropriate amount and duration. In the event that they're unable at the time of dissolution to come to an agreement, the alternative is that they go to trial on the issue, in addition to any other issues that may be outstanding. And the judge would determine if alimony is appropriate, and if so, how much alimony is appropriate and for what period of time. Now, in the event that the parties leave the agreement silent on the issue of alimony, it's important for them to understand that this silence is generally not going to be deemed or interpreted as a waiver by the court. Because in Connecticut, as I said, the waiver is a permanent waiver, the courts really need to know that the parties intended to permanently waive alimony. And so generally, if an agreement is silent on it, it's not sufficient for the court to determine, yes, they understood and intended that they were voluntarily waiving their right to any kind of support for the rest of their lives from this specific spouse. So generally, if the agreement is silent on the issue, the court is not going to interpret that as a permanent waiver. The court would still make a determination at the time of dissolution as to whether or not alimony is appropriate, and if so, what the terms would be. So as you can see, this is a fairly complex issue that needs to be addressed within the agreement. It's best to address it within the agreement to the extent the parties can come to an agreement on it in order to prevent any kind of uncertainties or disputes or litigation in the context of a divorce. So because there's the possibility of including language that may make your agreement unenforceable, or perhaps open you up to future disputes down the line if it's not addressed thoroughly enough, it's important to consult with an attorney during the drafting process to really ensure that your agreement is thorough, is comprehensive, and is protecting you and your assets in the future.
Attorney Fox is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Fox at efox@mayalaw.com, and please visit mayalaw.com for more information.